Tonight on PM Express, another milestone in Ghana's democracy as the Supreme Court settles yet another election dispute. Remember, it's our second, and for the past 3 months, the judges, the petitioners, the respondents have been going through the process to arrive at the very conclusion delivered today. What questions or what cues are there for us as a country and subsequent elections? And so tonight, 2020 election petition, making sense of the Supreme Court ruling. Let me just run you by the 5 questions that were raised by the court today before the ruling. And it started with whether or not the petition discloses any cause of action, that is, if there is any legal grounds for the petition, whether or not the second respondent, Nana Dudankwa Akufo-Addo, met the Article 63.3 threshold of the 1992 Constitution. This provision states that a presidential candidate must obtain more than 50% of the total valid vote cast to be declared president-elect. Whether or not the second respondent, Nana Akufo-Addo, still met the Article 63.3 of the 92 Constitution 1992 threshold by the exclusion or inclusion of the Petition South constituency presidential election results, whether or not the declaration by the first respondent EC on December 9 of the presidential election conducted on December 7 was in violation of Article 63.3 of the 1992 Constitution, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. And that the EC breached Article 63.3 on the declaration of the presidential results based on the data used for the presidential declaration. So these are 6 reliefs also that the petitioner, John Mahama, sought the court to do. So it started by saying the EC breached Article 63.3 on the declaration of the presidential results. And based on the data used for the presidential declaration, none of the candidates got 50+1 to be declared president. That the declaration by the EC is unconstitutional, null, void, and of no effect. An order annulling the 2020 presidential election declaration, and another order preventing the president from holding himself out as president-elect. And the petitioner also asked for an order directing the EC to conduct a second election. Then we went through the processes for 3 months. The final judgment. The Supreme Court concluded that the petition is dismissed as it has no merit. On issue 1, the Chief Justice Enin Yeboah said the court is convinced the petitioner raised a reasonable cause of action. He says the argument by the first and second respondent that the petitioner had a weak case is not enough grounds for the petition to be dismissed. On issue 2, the Chief Justice said there is no doubt that the chairperson of the Electoral Commission made a mistake by announcing 13,434,074 instead of 13,121,111 to be total valid votes cast. According to him, the threshold to declare a president should be based on the total valid vote cast and not the total vote cast. And since that was rectified by the chairperson, it is wrong for the petitioner to hold the EC to the error made. He said the Apex Court is of the opinion that the chairperson had the right to correct the mistake when it was noticed. On issue 3, Chief Justice Enin Yeboah said at the time the petition was filed, the results of the Petition South constituency election had been added and therefore was known to the petitioner. And he says the cross-examination of the NDC Sasiedu Nketia established that the second respondent had more than 50% vote +1. He had met that threshold. Again, even if all registered voters in Petition South of 128,018 were added to the petitioner, the second respondent will still make the more than 50% threshold. On issue 4, the Chief Justice said it is the opinion of the Apex Court that the error made by the EC chair did not affect the results and was not in violation of Article 63.3 of the Constitution 1992. He says there is no denying the fact that the EC chairperson made an error. However, based on available evidence, it was corrected. And on issue 5, the Chief Justice said, although the court finds the accusation of vote padding very serious, it observed that this allegation was not proven by the petitioner. And based on this, he says the judges are settled in their minds that even if there was vote padding, it did not in any way affect the outcome of the election results. So the ruling per CJ, Justice Enini Abuan, he said the petitioner did not adduce cogent evidence to back this claim. The court expected the pink sheets to be exhibited to prove the claims. Allegations of wrong aggregations of votes were not proved. Even if the vote padding was accepted, it will not impact the validity of the votes of Nana Akufo-Addo. Tonight, making sense of the Supreme Court ruling of the election petition hearing, the 2020 election petition hearing. Stay with me. I would introduce my guest to you shortly. Welcome back to PM Express. My guest tonight, Frank Davis, is member of Akufo-Addo's legal team. Abraham Amaleba is NDC Director of Legal Affairs. Oliver Maunsebaka Vomawo is Chief Technical Advisor of the University of Ghana School of Law Democratic Vigilance Project. Ransford Jampo will be joining us later in this discussion. He is Associate Professor of Political Science at the University of Ghana. Let me start with you, Mr. Davis. I heard you describe today what has happened as a naked truth manifesting at the Supreme Court. But the petitioner, former President John Mahama, says a lot of things that his first witness, PW1, which is Osie Dunkechia, said in his testimony was taken out of context and on that basis dismissed the case. What's your own interpretation of Mr. Mahama's description of what has happened in court? Hello, Mr. Davis.
Thank you. Thank you. Can you hear me?
Loud and clear.
Can you hear me?
Loud and clear, Mr. Davis.
Can you hear me?
Loud and clear. You're on PM
Thank
Express.
you. Good evening. Thank you. I say good evening to your cherished listeners and viewers. I must take up this opportunity to thank the good people of Ghana, you, the ladies and gentlemen of the press, for bringing this election petition to the doorstep of the ordinary Ghanaian. I'm gratified by the fact that the televised coverage has brought to the home of every Ghanaian what happened and transpired in the Supreme Court. So we are not given to speculations, suppositions, and circumstantial truth. Whatever happened in the Supreme Court has been beamed live for all of us to see, hear, and comprehend. Well, I listened to some aspects of the speech given by the petitioner John Dramani Mahama on the verdict, or for that matter, judgment of the Supreme Court. I must say, with the greatest of respect to the petitioner, that litigation should at a point in time come to an end. When the justices of the Supreme Court is the highest court of this land. Our brothers next door, the Nigerians call it the apex court, the highest court of this land. And when their decisions are rendered, at least expect that the former president of this republic would use the kind of language, with the greatest respect, that he used to describe the judgment rendered by the justice of the Supreme Court. But I must say that this election petition is not novel. In 2013, His Excellency the President of the Republic and Commander-in-Chief of the Armed Forces, President Nana Akufo-Addo, also launched a similar petition in the Supreme Court of Ghana. At the end of the day, the decision of the court and the judgment was to the effect that the justices of the Supreme Court are decided by the majority decision of a 5-4 majority in favor of the ex-president John Dramani Mahama, and he was validly declared as having been elected president of the Republic. In this election petition, it was a unanimous, I repeat, decision and judgment of the Supreme Court. 7 justices of the Supreme Court were certain in their minds that the petition had no merits. The least I expected was for the president to acknowledge that the justices of the Supreme Court had spoken. Because when the verdict of the Supreme Court was delivered in 2013, His Excellency the President, Nana Dankwa Akufo-Addo, even though said that he disagreed with the judgment, he accepted the verdict and accepted in consolate terms without ridiculing or saying anything bad or ill about the judges of the Supreme Court. I think with all due respect, that this is the way to go. But if judgment is given and an ex-president who benefited from the same justice of the Supreme Court should say the kinds of things he said tonight, I am disturbed.
All right. Let me bring in Mr. Amaliba here.
When it happened, please.
Okay.
When it happened in 2013, excuse me, can I talk? When it happened in 2013, it was good. But when it happened in 2020, because it did not find favor with the justices, it is wrong. And he uses such language as desecration of the judicial system. I think these things should be deprecated. We owe it to ourselves to make sure that our justice delivery system is accepted by the totality of the Ghanaian public. And when we lose cases in court, there are avenues for which we can seek redress. This generalization and rendering down the justice of the Supreme Court is not something which is acceptable, much more when it comes from an ex-president of this land. Okay. I'm disappointed.
Right. Mr. Amaliba, the petitioner, Mr. Mahama, a while ago, described the Supreme Court's characterization of Asiedu Nketiah's testimony as misinterpreting what was actually said, and on that basis gave the ruling in favor of the second respondent, President Akufo-Addo. But the Supreme Court gave blow-by-blow explanation as to why the case was dismissed.
Let me say good evening to your viewers. What the petitioner said was that clearly the Supreme Court took out of context the answers rendered by the General Secretary. Those were his exact words. And proceeded on that basis to then make it look like Asiedu Nketiah, the General Secretary Asiedu Nketiah, was more or less a star witness to the respondent's case. I think you heard him say that. So that's why he said.
Yeah.
The petitioner is clearly unhappy, and he thinks that the judgment is a travesty of justice. He feels that he was not given a fair hearing. My colleague on the other side has indicated that in 2013, Nana Akufo-Addo lost, and he took it in his strides. But in that hearing, the Supreme Court granted his application for interrogatories. Can you say same today about this hearing? The petitioner also applied to inspect original documents which were in the custody or are in the custody of the EC. That wasn't granted. The petitioner requested for admission of facts. That one was also ignored. And so, if the petitioner today, after the judgment, disagrees with the Supreme Court, I think it is within his right. You heard the judgment, and that the EC admitted that it committed errors, or it made some errors. Wouldn't Ghanaians want to know how this error came about? And what is the witness box? It was the same EC who, in her declaration, said that she did this work to the glory of God, and that she did the work in accordance or in consonance with the rules as laid out in CI 127. And so if she actually believed that she executed her mandate in accordance with law, what made her to run away from the witness box? And so the petitioner then made a correlation to what happened in 2013 and said that in the 2013 election, Afarijan, who was then the electoral commissioner, was eager to take the witness box. That's not what we are seeing today.
But that matter was settled by the court. The court said they could not force any witness to mount the box.
See, and that's where the petitioner in his address today indicated that the job that had been entrusted in the care of Jemensa is not her personal endeavor. This is a constitutional duty bestowed on her and trusted in her care. She cannot, having sworn affidavits and indicated that she was going to take the witness box, then turn around and say, I'll not take the witness box. And that is food for everybody. So she, in representing to the whole world that she was going to take the witness box, did a lot of harm and did not take the witness box, did a lot of harm to the petitioner. You remember in the interrogatories, one of the reasons why she didn't take the witness box was that, oh, you can ask me these questions during the cross-examination. The petitioner believed in that. The judges even believed in that. I remember when there was a review of that application, one of the justices asked our lead counsel, Judge Chikata, can't you ask those questions during cross-examination? We all heard what the judge said. Because the judge believed that she would take the witness box. So what she actually did by doing a 360-degree turnabout was perpetrating fraud on the court and the petitioner. And that shouldn't have been allowed. She was supposed to take the witness box, explain to the people of this country how these errors came about. We needed to hear from her. So the petitioner is frustrated at the failure to give him fair hearing, which is basic, which is a constitutional requirement. And so that is where his frustration is all built around.
Well, you talk about fair hearing. If you said the petitioner was not giving fair hearing, his witnesses, he even wanted to give 5 witnesses, but at the end, it was only 3 of them that actually mounted the witness box. I'll come back to that, but let me bring in Mr. Vomawo. Mr. Vomawo, what's your preliminary observation in the Supreme Court ruling and the characterization of the witnesses of the petitioner?
Thank you for bringing me to the conversation. I appreciate the chance to join the discussion. You know, I've heard my colleagues try to characterize the court's decision and even share their opinion as to how the citizenry at large and even the petitioner or the respondent need to react to the decision. You know, to believe from Davis, this is a moment where we must all gather together and sing Kumbaya and accept that this is the biggest victory in our electoral process or judicial process we have ever seen. And we've seen clear signs of frustrations expressed by Abraham on the matter. I think for me, one of the biggest questions we need to ask is whether what we have witnessed has been a sort of a truth and reconciliation process which allows us as a nation to chart the path forward with an honest sense of what truly transpired in the last election. I do not necessarily think that we come out of this process having that feeling. You know, there are several ways to reflect on the significance of the decision. But it seems to me that the constant refrain and or perhaps the more popular way in which people are processing the decision is to hurriedly and perhaps without grounded nuance say that the decision advances our democracy or that it grounds it in some shape or form. Now, I am always skeptical of the single narratives that decisions by courts do not advance democracy just because they were made. There has to be a more complex and nuanced matrix by which we look at these decisions. And also we need to be complex in the significance we attach not only to what was said in the decision, but also what was left unsaid. So, for instance, it is easy to bring down the decision to who won the 2020 presidential elections, but I think there's more, or who lost it, but I think there's a lot more to that. And it is for this reason that the register of winner and loser, or the winner-loser framework of analyzing the decision is essentially unhelpful and very limiting. You know, so even as the respondents do their victory lap and the petitioner goes to bed with a sullen face, I think the sun will set on our democracy. And with the crack of the early morning dawn, we must wake up and also ponder over how the decision affects democratic governance in this country. I'll give you a few examples of the types of issues that have been drowned out by the vuvuzela of the respondents. First and foremost, an election petition is almost always a referendum on the conduct of the elections manager, in this case, which is the Electoral Commissioner. And in times like this, we ought to determine whether the decision leaves us in the position to better hold the election manager to better account for the constitutional duty we have entrusted to them. Or do we continue to shield that manager from scrutiny by clinging on to legal aphorisms that make light of significant procedural irregularities? You know, true, it may be appointed to all human institutions to commit errors every now and then. But it's the cause for us to treat and make light of infantile and rookie mistakes that go to the heart of the confidence that Ghanaians repose in the democratic process. You know, I mean, unfortunately, irrespective of the view we hold of the weight that must be accorded to the petitioner's case, or even of what the witnesses said on the stand, Ghana has come out of this court process less certain that the EC has covered itself with glory. And let me give you an example. How many Ghanaians could say with certainty that they knew what the total valid votes were at the end of the election? And this is not a light point that should be a point that should be taken for granted, because the heart of Article 63 of the Constitution is that the second respondent can only be elected on the basis of total valid votes. Now, if we come out of the election not clear on what the total valid votes are, it is difficult to say that the mistake that the EC has done is innocuous. There's nothing innocuous in my view about this fact. So yes, legal concept and procedures may treat the point lightly, but when it comes to reinforcing faith in our elections and the electoral process, those innocuous mistakes undermine it in ways that puts our union in great jeopardy of unraveling. Secondly, if we still have time for it, another example I could give about this decision is that the Supreme Court continues to hold political party agents to a higher standard than the elections manager. This happened in 2013 and it happened again today. And as I have had occasion to say, it is important that we do not treat our election petitions as some private contest between two private individuals. It's far from it. It's not a litigation for a 2-acre plot in my hometown in Guanacope or Domelevo's hometown in Togo. It is not a contractual dispute between two market women at Agogloshi. No, the conduct of an election, a presidential election, is a grave constitutional duty that we entrust to a constitutional body. So it seems then disproportionate to me that we will make mountains out of the signatures of party agents on forms, yet we minimize the EC's own missteps as being innocuous. So I think generally this is how I would look at the decision and sort of unshackle myself from the frame of who won or who lost.
Mr. Davis, how do you react to those who are of the view that you used overly technical means to secure this victory, and the decision of both first and second respondents not to testify had a negative impact on the court's ability to reach a fairer conclusion?
Aisha, I'm getting a bit worried and concerned about the kinds of things that my friends are saying. I mean, we are lawyers. We train lawyers. We are trained lawyers. And listening to my friend who just spoke, I get much more worried when lawyers speak the way he spoke. I mean, we should learn to stick fidelity to our profession. He was saying a lot of things. I'm wondering, he's at the University of Ghana School of Law. I mean, come on, with all due respect. He's a lawyer. He's a trained lawyer. He's a trained lawyer. So this fetish about the EC chairperson going to the box to testify and all that, what has it got to do with anything that happened? He's a lawyer. He's a trained lawyer. No court can compel a party to adduce evidence in court. No court. The authorities are legion. There are a plethora of cases which establishes that fact, that no court can compel a party to adduce evidence in any court of law. So this rhetoric about accountability, the EC chairperson, and so what? Every plaintiff or a petitioner comes to court on the strength of his or her own case. That is our legal jurisprudence. You don't rely on the weakness of the defendant's case or the respondent's case to prove your case. I did not draft the petition for John Dramani Mahama. He had lawyers who drafted the petition for him. And from the get-go, they knew what they were doing in court. This business of, whatever, is it to the glory of what? They drafted their petition, they had their pleadings. The onus on them, as lawyers from the get-go, they knew that the burden of proof was on them. You have led evidence. The respondents have cross-examined your witnesses. And the respondents are saying that there is no obligation on us to lead evidence, for God's sakes. And lawyers would come to address the general public, Ghanaians to understand what went on in court, and they will talk the way they are talking. I'm disappointed in them. My good friend Amaliba, he's my very good friend, he knows it. The kinds of things they say, this business about affidavit evidence, please, let's grow up in the law. Let's grow up in the law. Let's grow up in the law. The affidavit evidence is not a witness statement, please. It is not a witness statement. It is an affidavit.
All right. So, Mr. Amaliba,
it is an affidavit. It is not. Please let me talk. You gave him too much time to talk.
Okay, Mr. Amaliba, let him make his point and I'll come to you shortly.
And please, when an affidavit is deposed to, it does not translate into a witness statement. You file a witness statement, you serve a witness statement, and you testify in court. You give a judicial oath before you testify. So even if there's a deposition in a witness in an affidavit, consequent upon an application and a ruling delivered, and one of the reasons for the ruling is that, well, in interrogatories, if you don't get the opportunity for the interrogatories, you can ask what you want to ask in cross-examination. Cross-examination comes after evidence in chief. With all due respect, colleagues, cross-examination comes after evidence in chief. So if the witness does not testify, how do you cross-examine? And Mr. Abraham Amaliba, in 2013, the application for interrogatories filed by the petitioners was dismissed. Learn from history and go and read the reports. The interrogatories was not granted. It was dismissed. So please don't come and sit on public discourse and disabuse and then misinform the public.
Okay.
The interrogatories in the 2013 elections was not granted. Mr. Ibrahim Amaliba, Esquire, Council, please.
Okay.
So don't sit on television and say what you're saying.
All right. So
and please, you see, we should not denigrate. We should not denigrate what happened in court by moral euphemisms and personal idiosyncrasies and being I don't know what to say. I mean, Mr. Whatever, I don't know your name, or whatever, but please,
all right. So
please, I beg
think
you.
Mr. Amaliba,
You are the Ghana School of Law. Let us learn fidelity to our profession.
Okay.
This business of whether it resonates with the public or what. 6 million plus people voted for the second respondent, who is the president. 6 million plus other people voted for the petitioner. We are all Ghanaians.
Okay.
So don't let it seem as if others are more Ghanaian than others.
Mr. Frank Davis, let me allow Mr. Amaliba to respond to some of the issues you're raising. Mr. Amaliba, you say you were not given fair hearing because you were the petitioner's lawyers were not allowed to cross-examine the EC chairperson, even though she had elected or she had already promised that she would allow herself to be cross-examined. Mr. Frank Davis says affidavit is not same as promising to allowing yourself to be cross-examined. How do you respond to this? Hello, Mr. Amaliba. Kindly unmute for me. Okay. Whilst I try to get Mr. Amaliba to come on to respond to some of the issues raised, let me bring in Mr. Vomawo. Now, the petitioner, former President Mahama, has reacted to the ruling, and he says his principal witness, Johnson Asiedun Ketia, his testimonies were taken out of context, and that was the reason why, or that led to the dismissal of the case. What's your appreciation of Mr. Mahama's account?
Thank you again. Before I react to that, I think my colleague, Frank Davis, is still in a combative mode. I can see that perhaps the shirt he was wearing in court is still on, and that he hasn't lost that framework of which he's engaging the matter. But I think that those of us who were not litigating the matter have the benefit of taking a step back and reflecting on the broader significance of the matter. That does not limit us into the register of, oh, my client won or my client lost. And I think that you are perhaps an inability to appreciate that broader significance of the case is disabling you from properly commenting on the course and the role of other lawyers who are looking at the matter. It is not a combat between whether or not the court, it's not only a question of whether or not the court should have upheld the respondent's right to defend their claiming or put up their defense in a manner in which they deem appropriate only, but there's a broader issue that needs to be discussed with the policy background and the sort of what we understand the election is representative of our democratic process. But even on the law, I can even challenge it. People have a different view that you have set up. So we can disagree on the content of the law. But we must also be prepared to analyze the law beyond what we consider to be the narrow limits of what we consider law to be. Now, the question you have asked me as to the petition, the petitioners claim that the witness was misrepresented or misquoted. I think that a lot of us are still we're all having had the full benefit of the judgment. And I think it is a bit premature for me to be able to concede to that claim. I mean, at least from the very least, I do know that the court make references to statements in there. And it will be insufficient for me to say that because statements of the witness were referred to, due consideration were given to the statements of the witness. What I do know is that the quotations were made. As to whether or not they were taken out of context, would have to juxtapose the decision with the full record of what transpired on the stand to be able to make that claim. Mm-hmm. And also to add, there were 5 issues were set down for trial. I am unable to say whether or not the witness statement spoke to all 5 issues, or on which particular ones the petitioner deems that the witness was misrepresented or misquoted by the court. So I think that would be my stance on that, being unable to say clearly in which direction this is going.
Now, thankfully, Mr. Amaliba is back. Mr. Amaliba, what's the way forward as Mr. Mahama's view on the Electoral Commission? He is saying that and you have actually indicated that he wasn't given fair hearing. Your colleague says swearing an affidavit is not the same as the first respondent saying that she would indeed mount the witness box to be cross-examined.
Can you hear me?
Loud and clear, Mr. Amaliba.
Yes. Let me first take strong exception to the strong language used by Frank Davis. We can all go
all right, Mr. Amaliba, we are having challenges with your line. Let me take a break on PM Express and we'll try and fix your line so that we'll come back to this discussion. When I return from the break, we'll hear from Mr. Amaliba on the way forward and also look at the issues that people are raising, that ruling did not give any roadmap for electoral reforms. How much important is this one? Stay with me, I'm coming right back. All right, so welcome back to PM Express. Mr. Vomao, you had indicated earlier before the judgment that you were hoping that there would be no reason to go for a review. Do you still feel same after the ruling?
Yes, I do think that there's really no reason to go for a review, both on the law and also on the political relevance of going for a review. I think that if anything, my opinion on the need not to go for review was confirmed by the intervention of the petitioner today, and I do think that they are going away with some sense of taking or putting in as much more on the putting forward sort of the political implications of the decision and their disaffection with the court's ruling on much more in the political in the public commentary, rather than subject themselves to a process where, based on past on what has happened in the court and also by the way in which the judgment is set up and what you need to even win on review, that a review is not the best forward for a decision like this.
Prior to the ruling, there were those who felt that the ruling must provide a roadmap that will address electoral challenges identified in the 2020 general election. Satisfied with the ruling today?
So this is another question which becomes a trap for Frank Davis today. He might pop a vessel if you engage in questions which go beyond did my client win. And for others like myself, I do think that a decision like this provides a forum for the Supreme Court in its authority to reflect a bit much more on how the elections were conducted, with an eye on improving the substance of how we chart the path forward from here. And I do not think that they took that opportunity to provide that. It goes beyond whatever view you have of the weakness or otherwise of the petitioner's case. No, I do think that, especially as this is the second time in the Fourth Republic that the matter like this has come before the courts, that they seize the opportunity, as they have done in the past, to reflect on how we can improve electoral processes in the country and set forth their thoughts there. And perhaps the poverty of the court's decision comes from the fact that each of the justices did not write an individual opinion. You know, I think this matter is going to be talked about in many ways. And generally, I think in law and in other jurisdictions, perhaps not so much in this case, every time the court speaks with an unanimous voice, it's supposed to carry the full weight of the bench. It's supposed to put forward the strength of the entirety of the bench in speaking with one voice. But I do think, and if I was on the court, that opportunities like this should not be passed up. Each individual justice must speak with their own voice and must set out clearly for historical purposes their own appreciation of the facts and how they set it forward. If you've looked at some of the greatest Supreme Courts we've had and some of the decisions that have come before them, some of the biggest landmark cases we have, you would hardly ever see the court give one judgment or unanimous judgment. All the other justices appreciating the significance of what is before them, would set out their view of the law and how we progress forward as a democracy. And I think that's the loss in trying to appeal for to carry the weight of the court behind one judgment. We have lost the benefit and the richness that will come from the diverse tapestry of the unique voices of the different justices that it will bring to bear on the process.
Thankfully, Mr. Maliba is back on phone. Mr. Maliba, you are talking about the way forward for the petitioner, former President Mahama, and also reacting some of the issues raised by your colleague, Frank Davis.
Exception to Frank Davis' arrogance, and I think that I will not countenance that again if it descends in that way. But let me indicate that I still maintain that interrogatories were granted in 2013. What was not granted was the inspection of documents. So he should also go back and check his records. The next point I want to make is that he has indicated that no court can compel a witness or a party to give evidence. Yes. But he should also check the case of Adamu Sakande, where in that case, Adamu Sakande refused to take the witness box, but the court compelled him to take a witness box.
But this issue was raised by Mr. Chatuchikata in court, and the judges still went ahead to dismiss it.
But that doesn't mean that in Adamu Sakande's case, he also decided that he wasn't going to take the witness box, but the court said that he should take the witness box. So that is what I want to make clear, that there are some instances where the court, because of public policy, because of the fact that it is important, it is of national interest, they would insist that you take the witness box. And I've just given the case of Adamu Sakande. Never mind that the Supreme Court did not take that from our counsel. But nonetheless, it did happen in Adamu Sakande's case. Now, you see, the respondent has indicated that this is the end of the road, and you heard him articulate that clearly in his speech. He has indicated that even though he lost the petition, as was articulated by the Supreme Court, nonetheless, we have won in the heart and minds of Ghanaians. That, for me, is very key. Because this petition is also a political petition. It is a political-legal petition. Whilst we were there in the Supreme Court dealing with the legal matters, there were some people who were also outside the Supreme Court dealing with it politically. And I'm saying that we have won the minds and hearts of Ghanaians. The fact that the EC commissioner refused to take the witness box has had a dent on the reputation of the EC. Now, people are beginning to agree with our allegations that she deliberately, ensured that she conducted elections in such a way as to give some advantage to the MPP, and for that matter, Nana Akufo-Addo. Because if you have nothing to hide, you will not be running away from the witness box. And so I am gratified that we've been able to chalk that success where in the minds and hearts of Ghanaians, we are the victors. The next point is, would we go for a review? I do not think so. I think that looking at the circumstances and looking at the way we had all our applications dismissed, it doesn't make any sense for us to want to go for a review. And I think that clearly this will be the end of the road. And what we can do as a political party is to begin to strategize for 2024. My only fear is that with this kind of ruling, it will make people begin to see the polling station as the only place that you can win elections. And you have to win the elections there by hook or by crook. And I'm talking about violence. There's likely to be heightened or increased violence at the police station because of what we have seen today. So I think that as a political party and as a member of the legal team, we shall take the judgment, analyze it, and then appropriately give our advice to the party.
Do you agree with the court that the second and third witnesses, Dr. Kwesa White and Rojo Metonunu, disappointed the petitioner by leaving the strong room and then turned around to give fanciful tales, as the court puts it, with their testimonies?
On this score, I would want to borrow from what the lecturer from the University of Ghana said. It appears we are, as a nation, beginning to put so much premium on political party agents than the Electoral Commission. In some countries, and I know in the U.S., they don't even have an electoral commissioner, and yet elections go on well. In some countries, you don't even have political party agents, and the elections go on well. How about the conduct of the electoral commissioner herself? Why did the court refuse to believe the narrative of the two agents when they indicated that it was the electoral commissioner who asked them to leave and go and talk to the petitioner? And so, for me, the fact that the court did not say anything with regards to the conduct of the electoral commissioner, but only chastise, or if you want, pass comments on the two agents, is a clear indication that we are beginning to pay so much premium on agents, when indeed the work belongs to the Electoral Commission, and the Electoral Commissioner, her conduct in the election must also be a matter of concern for the court as well.
Mr. Frank Davis, I know you've been briefing the president on the outcome. He must be very happy with you, but Mr. Mahama announced a while ago that his lawyers did pro bono. Did you do same?
I don't think I have to answer this. I don't think it's part of the discussion. Whatever engagement we have with our client, I mean, it's privileged. I don't think I have to answer this question. I really didn't understand why you're asking this. So can I go ahead and deal with the issues?
Go ahead.
As it was pro bono or not, it's not for me to say. Yeah, please, with all due respect. Now, I see that, with great respect to you, I'm cocooned between two people who are sharing similar views. I mean, this has not been, the practice. So I'll try as much as possible to answer both of them. So give me some limited time to do same, with all due respect. Now, I take exception, you see, to when we are having academic engagements and legal exercise. It does not lie in the mouth of any of us to say one person is being arrogant. I take exception, Abraham Amaliba, you are my junior at the bar. So don't use such language.
Mr. Davis, we don't have much time, so let's stick with the issues. Arrogant. Let's stick with the issues so that we can make up.
Yeah, please, when he says so, you said nothing. Just leave me and let me discuss the issues, please. Don't tell me, Abraham, that I'm being arrogant, please. I don't take particularly good acceptance of that.
Mr. Davis, let's stick to the issues. So we have limited time.
Please, let's go on.
Yeah.
Please, let's go on. Now, a matter is determined in court based upon the issues that are set. In the Supreme Court, we have something called memorandum of issues. So the issues are set, and the justices of the Supreme Court determine the matter based upon the memorandum of issues that are set. There were issues set in this trial, right? And the judges took the issues one after the other. Unless we want to say that we didn't listen to the full rendition of the judgment. It was not a ruling of the court, it was a judgment. a full rendition of the reasons that were given point by point. And Mr. Womo, you were not in court. I can understand that, but I was in court, so I listened to the full reasoning. It was 2 hours from 10 a.m. to 12 noon, and the judges gave a pinpoint reasoning for every issue. At the end of the day, they came out with a reasoned judgment. Now, as to whether there are moral issues or other considerations which other parties will take to heart, it's not part of the law. There are no moral persuasions in law. We deal with the strict dictates of the law, and the justices of the Supreme Court deal with the law. There are other emotional aspects of whether or not the chairperson should have mounted the box or not. Please, lawyers, it's not for us to say. Let us leave that for those who are not literate in the law. And the evidence of Asiedu Nketia, the petitioner says he was misconstrued or misinterpreted or misunderstood by the justices. The justices quoted copious portions of the cross-examination conducted by Second Respondents Counsel, the Venerable Akoto Ampao, Anthony, and the star witness. Of course, if somebody is described as a star witness, I mean, we are all lawyers. Your principal witness is your star witness. And we all knew that Asiedu Nketia was a star witness of the petitioner. Pastor White and Robert Joseph Metanunu cannot be put in the place of Asiedu Nketia. Asiedu Nketia was a star witness. And the cross-examination elicited from him was what the judges used in the determination of the issues that confounded the court.
All right. So for you,
at the end of the day,
I have just 1 minute. Kindly wrap it up for me.
Electoral matters. Please, 2 of them spoke. I'm the only one speaking. Don't rush me. I beg you, please.
Mr. Davis, we have 1 minute to leave. Kindly wrap up for me.
The electoral, we all know in electoral matters that the percentage of votes which are cast for each candidate is a determinant of the total number of valid votes cast. The total number of valid votes cast, and not the total number of votes cast. And this was something which was accepted, and I must say candidly, by Johnson Asiedu Nketia.
Right. Thank you very much, Mr. Davis.
Is the total number of valid vote cast.
That's all time will allow us. It's only fair that I give Mr. Vomawo in just a second your final words. Just a second, Mr. Vomawo.
My colleague Frank says, or what views he holds of the decision. First of all, let me clarify that I do not join common cause with Abraham on any matter. But importantly, he needs to appreciate that once a decision has been made by the Supreme Court, it's a decision that belongs to the people of Ghana. The mechanisms and the way in which we criticize or review and discuss the case go beyond his perception of the law as the respondent's lawyer. And the way in which we discuss it may not conform with his view of the law, but it doesn't depreciate our view whatsoever. Those are my final words.
I'm grateful for your time. Mr. Frank Davis is member of Akufo-Addo's legal team. Abraham Amaliba is NDC Director of Legal Affairs. Oliver Mausi Baka Vomawo is Chief Technical Advisor of the University of Ghana School of Law Democratic Vigilance Project. And I'm grateful that you all joined me. My name is Aisha Ibrahim. Many thanks for watching. Enjoy the rest of our programs.